Private judging is more, I think, akin to the regular old kind of court-based process, but it's similar to mediation in that it's an opportunity to streamline the case a little bit and to have, some undivided attention from your bench officer. So what it is, it's just like, taking the public court system and privatizing it. That's what it is. You just, find who you want your private judge to be, and that could be a retired, bench officer of some kind, or just a highly regarded, practitioner that is willing to serve in that capacity. And then that person actually is appointed directly by the superior court. So you send a stipulation and order appointing the private judge to the superior court, so the superior court will sign off on that. And then you have your private judge set up. So again, all the same rules apply. It's the same situation as if a public county judge were hearing the case, but it's just someone in private practice that's doing it instead. But all the same rules apply. Ordinarily, with your private judge, you're going to get into what we call case management early, which means we're going to talk about a roadmap for, all of the discovery stuff that may need to be done, if depositions need to be taken, if documents need to be produced, if there are like business valuations or any kind of other, kind of third-party professional input that is needed. All that stuff will get talked about at the very beginning with the attorneys. Typically, there are attorneys involved when you have a private judge. It's not very, in fact, I've never heard of two self-represented litigants hiring a private judge. I suppose it could happen, but ordinarily you're going to have representation on both sides. But early on in the case, you're going to sit down with the private judge. We're going to go through the roadmap of what the case is going to look like, with the eye toward really minimizing the unnecessary parts, but you can just kind of excise from your process, right? So it's much more streamlined. And then you're going to set up, if you need any hearings, you're going to set the hearings up. And again, you don't have to wait on the superior court judge. Typically, if you file a motion in court, it's going to be 6 to 8 to 10 weeks before you even get to make your argument, right? So you got to wait for an awfully long time. But with a private judge, you just make sure everybody's on the calendar, and you can have that heard pretty quickly if you need that. And a lot of private judges will actually step into the role of like a judicial settlement conference officer, so they can help parties talk through issues with the hope that the parties can find some route to resolution. It's not a true mediation setup, but even in public court, you have a mandatory settlement conference that you have to go to right before trial, and it's either a sitting bench officer or a pro tem bench officer that is going to help work through the issues before you decide that you can't settle and you have to go to trial. So a private judge can do that just as well. So again, it's another mechanism within the system to allow for quicker resolution. This can sometimes come down to the issues that are before the court, and particularly for like seriously complex businesses, like you've got 50 million or more in gross receipts, and maybe it's a family business, but the other spouse has been working in the business for the duration of the marriage, or even if it's a business that's acquired during the marriage, but only one spouse is operating it. So cash flow is kind of weird, and maybe there's just a ton of moving pieces. There's a lot of very specific law that applies to that situation. And not every county and not every judge has experience with those kinds of issues. And so, not to say that those judges can't, make a good determination. It's just, you're probably going to need a lot of experts speaking to those issues to make sure the court understands exactly, what's going on. So if you have a private judge that's familiar with those kinds of issues already, because maybe they've litigated it a million times, or if they're one of those bench officers that, maybe sat in LA or San Francisco or San Diego or some of our bigger counties where those are very common issues, maybe that familiarity is already kind of baked in. Right. So you have an opportunity to find somebody that's got the credentialing to really understand without doing too much extra work. The other reason you may want to do it is just for confidentiality reasons, right? Because these proceedings are not happening in open court. They are happening in a conference room somewhere, whether that's going to be at, the private judge's office or one of the attorney's offices, or like a conference room in a hotel or something. The public is not going to be there. So if you've got sensitive issues that need to be talked about in a much more private forum, that's a good way to do it. Now, a caveat to that is that any marital settlement agreement that's going to get attached to a judgment, so say you come to agreements or the private judge makes orders, that's going to go to the superior court for filing, and that's going to be part of the public file. There are things that you can do, though, you can do this with a public bench officer as well, but certainly with a private judge, you're going to want to talk about the opportunity to keep that marital settlement agreement out of the public portion of the file if that's important. So there are steps to do, to go through to do that. But again, that's another thing that very commonly comes up in the private judging realm. So when we're considering a case that might be appropriate for private judging, really the first thing I'm going to be looking at is any privacy concerns. Those can be an indicator right out of the gate that this is something that we don't necessarily want to have public pleadings in. That like if you've got a celebrity situation or just really private stuff that you want to keep really private, then a private judge is going to be able to do that. Again, none of the proceedings are going to be happening in open court, right? It's either going to be on Zoom or it's going to be in somebody's conference room. So privacy, I think, would be the number one indicator that someone might consider a private judging situation. We have control really over the process that's outlined in all of the various statutes in California. If you just go to regular old court, the county courthouse, and have things done there, you're stuck with their timeline on things. And because they are so busy, you often have to wait forever and ever and ever, and there's all kinds of delays for any number of reasons that issues sometimes remain unresolved. With a private judge, you can get very quick access to a decision from your bench officer pretty quickly, and you have the opportunity to to streamline things without too much muss or fuss. You just have a conference call with everybody, and you make some decisions about when things are going to be decided and how they're going to be decided. I mean, like instead of having a hearing, for instance, you could say, hey, why don't we just submit a couple of legal briefs on the issue, and you can just decide based on the briefs. Again, that's a very streamlined approach, and sometimes courts will do that, but usually that's after a few hearings have already happened, in open court. So there are lots of different ways that the bench officer can keep things, moving in a very time efficient way that you would not have in your arsenal if you were just in the regular county courthouse with everybody else and their brothers. If you have like for instance a move away situation, and there are some courts, I'm thinking of like Santa Clara and Alameda, big courts that have a pretty serious backlog on big like trial settings. But if you have an emergency issue, like for instance, hey, I just got a job in Alabama, I also have some family there, but the kids have lived in California for the last 10 years. I think it's going to be great to be able to move to Alabama, and the other side says no way. The kids are staying here, not sending them to Alabama. In those larger counties, maybe that isn't even an issue that gets in front of a court for a year and a half, right? In that kind of setting, and then you've lost the job opportunity, or you've had to go to Alabama in this hypothetical and live there for a year and a half before knowing what's going to happen with the kids, and that's not great. So if you had an opportunity to have a private judge that said, hey, we can put this on a 90-day calendar, and here's how everything is going to work, much better, much quicker resolution. But still, it's going to be a thorough approach. You're still going to investigate and have all the appropriate law that's supporting each position. You're just doing it in a way that's much faster. A question that I frequently get, and have for years in my private practice, and that is, hey, we want to keep everything, off the table, and we don't want anyone to be able to pull, our judgment from the court file and kind of look through it, and put something in the newspaper or something like that, right? Because that's what can happen with public records. What people don't often understand is even in mediation or arbitration or anything that's done outside of the courthouse, including private judging, ultimately you are going to have to submit a judgment to the court, and that judgment needs to be specific enough so that the court can enforce the judgment. So you don't have to put in all of the detail that you would ordinarily put into, like your preliminary financial disclosures, all the forms that have to get filled out. Those eventually do get filed, so those are part of the public record in the court system, in the superior court system. You can avoid that in mediation. So oftentimes the disclosure process itself is fairly truncated. You don't have to stick with all of the formalities of every single piece of paper that might have an asset on it that's at issue in the case. Make sure that's been served and reviewed and everyone has done their due diligence and yada yada yada. You can really short circuit that and just say, look, here's all the stuff we talked about it in mediation. Neither of us thought there's anything else. Done. And that can be much, much quicker, and nothing then gets filed with the court on that front. So there's no property disclosures in the court record. There's no income and expense declaration in the court record. That's just something that exists in the mediator's file. And then the marital settlement agreement that we can produce can be very high level. It's going to have to identify assets, right? But it's not going to identify values or anything like that, where really people are most interested in on the outside world. Now, there are some cases, and private judging, by the way, you can do similar things, but regardless, the end product is the most important thing. So when I'm putting something together as a mediator, I'm going to include, whatever detail I think is necessary. And some things do require a higher level of details than sometimes the parties are comfortable with. And they don't want things like that in the public file. And so there is a way that you can have kind of a separate marital settlement agreement that delineates all the detail and all of the information that you need, that's referenced and incorporated. It's the legal term. It's incorporated into the MSA, the marital settlement agreement, that gets filed with the court, but it is not attached to the MSA that is filed in the court. So all of that detail, again, just remains in the parties' hands as long as the marital settlement agreement contains enough information so that you can identify the thing later if it ever needs to be enforced. So again, there are steps. That's a very technical thing to do. There are steps involved in doing that. You can do the same thing in private judging. You can have the same order. And again, this is much more common in private judging, frankly, than it is in the mediation world. But there are ways to keep that detail out of the court file if privacy is your number one concern. On the parenting issue specifically, again, there's public policy out there that says that the courts really need to know what's happening with the parenting plan, what's happening with child support, because they want to make sure that the kids are getting the kind of life that they need in each home that's adequate for their upkeep, right? So there are some things that must be in the marital settlement agreement on the child custody and child support side. But if there's additional information that's just kind of secondary to those bigger picture items, then you can keep that stuff in like I say, in that private stipulation that's not or that is incorporated but not attached to the judgment itself. So you can do that with parenting stuff as well. It's just going to be a little bit more limited. They are almost identical, except that again, the private judging world still has to utilize all of the, the rules and, standards in the family code. So that is going to require a deeper dive into some of the financial issues probably, but on the privacy side, it's the same, right? You can have the same, discretion when you're submitting documents to be filed into that public file that you can with mediation. It's just in the private judging world, you're going to have to do things by the book. There's no short-circuiting anything. There's no truncating the process in private judging, except that you can maybe get rid of some processes that just don't apply to your case, which in itself makes things much more streamlined. The cost of private judging can be very, very high. And that is because you've got either, like I said, a retired bench officer or a very, highly respected, regarded, and experienced, most likely family law, certified family law specialist, someone that's been doing it for a long time as a practitioner. Their billing rates can be extremely high. So understand that it's not just as easy as going in there. They have to get paid. And so you can expect to pay as much, if not more, for your private judge than you pay for your own attorney. Now, if the issues really do, speak to the need for a private judge, then understand that that is an investment that you're making that's probably very, very good, especially if you get someone that does an excellent job and has a lot of experience in that realm. But it does come with a price tag, and mediation does not have that same price tag. Mediation is much more modest, and that's just because you're not getting all the bells and whistles. You're not doing all the same things that you need to do in a private judging case. You're really just, streamlining is the most important value in the case, right? And that means, it's going to take a lot less time, and there's going to be a lot less legal effort put into the end product.